The court system, court procedure. Now we're going to look at the really fun part of litigation, looking at the process to move your case through the courts in a trial. The parties. In a criminal case, there are two parties, the prosecution that represents the state and the defendant who has been accused of violating a criminal law. Remember, the prosecution is usually represented by a party called the district attorney. In many states, including North Carolina, the district attorney is elected. Now, the attorneys who actually prosecute most of the cases, also known as assistant district attorneys or ADAs, those positions are just regular jobs that any attorney can apply for. But the title of district attorney, who is the head attorney over the office, is in North Carolina an elected position, so you'd have to run for office. If you have a civil matter where you've got private individuals or corporations suing one another, then we have a plaintiff, which can be represented by pi, and a defendant, represented by delta. And then in the court, you have also two parties. If you're in the trial court, the court of original jurisdiction, you would have the judge, who's going to decide questions of law, and the jury, who is our trier of fact. So let's look at a little overview. These are the three main parts of a litigation. First, you have the commencement of the claim, then you have the pretrial process, and then the actual trial. So during the commencement of the claim, we're going to look at what each party does. Then in the pretrial process, we'll look at things, important steps to take in order to prepare for the trial, and then the trial itself. Commencement of the claim. So now here you have a copy of the complaint. You also have a copy of this in your Blackboard. The plaintiff commences or initiates, begins the lawsuit. All three of those things: commences, initiates, or begins the lawsuit by filing a complaint. That's literally what the document is called, and if you can see it here, it says complaint at law. That at law is sort of a holdover from when we looked at how courts used to be divided by law and equity. And so if you were in a court of law, you designated that on your complaint. And if you were in a court of equity, you would have put equity on it. Well, even though both law and equity are covered in one court now, we still sometimes will see complaints labeled this way. Or you could also simply title it complaint. This complaint lets you know where the case is being held. It's in California in the Superior Court, which, as we know, is a trial court. So there's going to be a judge and a jury. The plaintiff is identified, Suzanne Winters versus Mario Ramirez. Now, on the right of the complaint, you see a number written in, and that is the number that has been given. It's a docket number that's been given or assigned to this case. The first number usually represents the number of cases, which number you are in the court queue for this year. So this is case number 3026, and CVS means civil. The C means civil, superior. And it's 2017 because that's the year that the complaint was filed. If this were criminal court, you would not have CVS there. That's CV is for the civil, and the capital S is for superior. Then the plaintiff is going to go through and in numbered paragraphs set forth the facts that underlie the transaction. What happened? In this case, Suzanne Winters is alleging that she was hit while crossing the street riding her bicycle by a car driven by Mario Ramirez. Now, as we've talked about, once you have an incident occur and you think that you have damages and you feel like someone should have done something different, you still have to find a source of law that either gave you a right to do what you were doing or created a duty in the other person not to do something. So if you're looking at page 2 of your complaint, you will see in paragraph 6, the plaintiff points out which source of law she is relying upon. Here she's relying on the California compiled statute, and she gives the number and she quotes from it, because just like any good document, if you've got a reference of what you're relying on, you've got to quote from it and provide the information. And it states that drivers are to exercise due care to avoid colliding with any person operating a bicycle across the streets. So what this plaintiff did was she had a situation to occur. She was crossing the street. She was hit by a car. She felt she was wronged. She went to an attorney. The attorney had at her disposal different sources of law: federal and state constitutions, federal and state statutes, administrative law or regulations, contract law, uniform state laws, treaties and executive orders, and common law and case law. Case law is kind of encompasses all of those things. The attorney could look at any of those sources that we've looked at and then try to find where either the plaintiff had a right to cross the street or the driver had a duty not to, to yield to her. And ideally, you want to find both. And that's essentially what this statute here is saying, that that driver had a duty to yield and not collide to a person who was operating a bicycle. And then they proceed in the complaint to lay out in the specific ways that they believe the defendant breached their duty. You see that in paragraph 8. Then they ask for damages, and then on the last page, the attorney signs the document and identifies themselves. This is how you get a lawsuit started. The plaintiff files the complaint, but they have to be sure that they have identified sources of law in their complaint. If not, the defendant can get a motion to dismiss and get the case thrown out. Then, within 30 days, the defendant has to respond to the complaint. And in their response, it's literally answering the complaint, and that is what it's called, the answer. So the defendant answers the complaint, and as you see, the answer is not very detailed, is it? It isn't, because when you respond to a complaint, you're really going to do one of 3 things. You're going to either admit the plaintiff's allegations, you're going to deny the plaintiff's allegations, or you might admit part of an allegation upon what's called information and belief. To admit upon information and belief means I don't actually know that what you're saying is true, but I'm going to agree that it's true based upon what you have provided. That's the information and belief. So, other than that, the defense doesn't really say much. And I think I might have mentioned to you all, most of all my cases, I am defending a client. And as you can see, the answer is pretty short here. In this first paragraph, the defendant states that the defendant is without knowledge or information sufficient to form a belief as to the truth of the allegations of paragraph 1. And so then you want to go back and look at paragraph 1 of the complaint, like what do they say? And so they're essentially saying, I don't know if that's true. Yeah, you're saying that you were a resident of Centerville and doing certain things. I don't know if that's true. And so as a defendant, you don't want to admit anything unless you're certain of it. Now, some things you can ascertain, like if they say that you were driving on Market Street headed east at 3 o'clock, if you know you were on Market Street, you'd have to admit that part of the sentence. But if you're not sure it was 3 o'clock, you could say, admit it as to the location, but denied or deny the remaining allegations. You can actually pick apart what you plan to respond to. And that's actually important, because if you say admit it to something that actually turns out not to be true, you really don't have much recourse, because your response is treated as evidence and is admissible against you. Now let's look at the next piece, the first defense. Now, the defendant responds to the complaints and the allegation, but then they may have their own what we call affirmative defenses. Like affirmative defenses are what a layman might think of, or are reasons or excuses. Like, yeah, I ran over you, but it's because you were dressed in all black and it was 10 o'clock at night and I never saw you and you just sped out in front of me. So defenses that the defendant has, they need to plead them. They need to write them in their defense, their answer, as soon as they have them. So what does that mean? It means your attorney has to research all of your potential defenses before they actually file an answer to make sure we've got them covered. Then on our second page of the answer, you can see again your lawyer signs, but on this one I included so that you could see the certificate of service. Each party has to certify that they actually served the other party with a copy of the pleadings. The word pleadings refers to all documents that are actually filed with the court. All documents, anything that you file with the court is generically called a pleading. This pleading is specifically an answer. And so when the plaintiff sent their complaint, they filed a copy with the court, but they also had to get a copy served on the defendant. And the defendant is not actually in the case until the plaintiff properly serves them. Now, the requirement that the plaintiff serve the defendant of a complaint is a procedural rule. Remember we talked about procedural laws versus substantive ones? If a plaintiff fails to get their defendant served, i.e. formally notified of the case and in the court, they cannot do anything against the defendant. Even if they had a winning case, they've got to serve the defendant because that's a procedural rule that requires that the defendant receive notice before the case can proceed. After everyone has been properly served, complaint and answer are filed, everyone's in the lawsuit, then we enter into the most important part of any litigation, discovery. This is one element of a trial that is really not depicted in law programs and police shows that you see on television. They show police doing research and investigating before someone is apprehended or arrested, but you don't see really the discovery piece, partially because most law shows are criminal, and discovery really is something that's incredibly prominent in civil cases, although it also takes place in federal in criminal cases. So I think discovery is very important in civil cases, but you also have it in criminal cases. Make sure I make that clear. So what is the process of discovery? Discovery is literally the process of finding out the facts that underlie the case. Each side wants to find out as much information as they can about what happened and what the other side claims happened. This is why it's really important that when you are involved in litigation, if you have a legal dispute, you have to tell your lawyer everything. You have to tell them the truth. It's like going to the doctor. You can't hold anything back, because if you hold something back, you are handicapping your attorney. They can't properly defend you or properly assert your claims against the defendant if they don't know everything that happened. You can't be selective and hold back things that you think don't reflect upon you positively, or you think don't matter, or you didn't think anyone could find out. Everything you know, just like when you go to the doctor and you want a good diagnosis, you have to answer all of the invasive personal questions and the personal history, because they need that information in order to fully assess your situation. And it's exactly the same with lawyers. The facts make a difference. So how do we obtain facts during discovery? We've got three main methods. The first is written interrogatories. Written interrogatories, or written questions, are sent to each party in the lawsuit, which you have the attorneys are going to sit down with their client, and they're going to answer the questions, and they're going to put it in writing, and they're going to the best of their ability, answer truthfully all of the questions as much as they can. The next piece that we would pursue is making a request for documents. A request for documents is when you send a written request asking the other party to send you copies of all the documents that are relevant to the lawsuit. For instance, in the Susan Winters complaint that you have read, Susan claims she was hit while riding her bicycle, and she suffered damage to her bicycle and her injuries. So you would want to know and get documents from her substantiating the extent of her injuries. Did you go to the doctor? When did you go to the doctor? What type of doctor did you go to? What did they find? Will you require any rehabilitation? How much might that cost? Did you have pre-existing conditions? I'm going to request your medical records, and I, as the attorney for the defendant, have the right to do that if you are alleging that the defendant caused you physical harm. You'd also want to request documents relating to the bicycle. You read in that complaint, Suzanne Winters is alleging that her bicycle was damaged, and she claims that it was a really expensive bicycle. Well, I want proof of that. When you do your online trial, you're going to hear that Suzanne's bicycle was, over $1,000. Well, I'm not going to take her word for that if I'm the defendant. That might be a Walmart bicycle for $125, and she's just telling us that it's a $1,000 bicycle. We want receipts. We request in documents. We'd like to see receipts for your purchase for that bicycle. We'd like to see the handbook or any brochures that came with the bicycle. We want to know how old the bicycle is, because even if it was an expensive bicycle, if you've had it for a number of years, we can get depreciation. We're not going to buy you a brand new bicycle when you didn't have a brand new bicycle when you were hurt in the accident. So you see, the request for documents, it enables you to find out and to substantiate the other party's claims. So written interrogatories are questions that they have to answer. Request for documents gets you the documents that substantiate or are related to the case. And then the third tool that we use, and perhaps the most powerful, are depositions. In depositions, what we do is the lawyers will schedule the depositions of the opposing parties and sometimes their witnesses. Oftentimes they're witnesses. So we're going to meet with a court reporter, ask the party or a witness all of the questions that we can think we would want to know and want to ask during trial, but we're doing it before trial. And I want you all to make sure you understand that. Discovery happens before trial. This is doing like the homework. This is getting all the information about the case before you go to trial. Good lawyers do not ask questions during trial that they haven't already asked during discovery. You should know everything that's about to come out of the mouth of a witness or a party when you get to trial. How do you know that? Because you already asked them and you got their answer on the record during a deposition or an interrogatory. The depositions are taken under oath with a court reporter so they can be used in trial. The key reason for doing depositions, and there are several, I'm going to go through three. One, trials can take a long time, and sometimes it may be months or years between the time that the incident underlying the case happened and then when the trial occurs. So people's memories get fuzzy. People get, may move. People may be unavailable due to death or disability. If you've already taken their deposition close in time to when the incident occurred, you're going to get a fresher recollection of the facts. So we would think it would tend to be more accurate if you can get a deposition closer in time to when the incident occurred. And it preserves evidence in case a person does die or is no longer mentally competent. And then the third thing, and the most powerful reason to do depositions, is what I alluded to earlier. Because taking a deposition before trial allows you to know and to prepare for that witness's testimony during trial. So you will know what they are going to say because you've already asked them. But then, if that witness gets in the trial and changes their story, you have a way of impeaching them. To impeach the witness is to use prior deposition testimony during the trial to show that someone on the stand is lying. That is probably the most powerful use of a deposition. Otherwise, you really have no way to prove to the jury or to really expose to the jury that a witness is lying. If you don't have their prior testimony in a deposition, you can't really point out when someone's lying on the stand because it would just be your word against theirs. And also, I will note that on television, they always have attorneys essentially testifying, like just giving speeches during a trial and saying, aren't you lying, and this and that. That doesn't actually happen in real life. We can't do that. You'd be thrown out of court or, overruled. Attorneys can't stand up and just talk. We have to be asking a witness a question. The only time an attorney can just talk is during an opening or closing statement. The attorneys on television give like little mini soliloquies during a trial. We can't do that. So the only way to show the jury that the witness is lying is that after they give you an answer that you weren't expecting, something different than what they told you earlier, then you pull out the deposition. You hand it to them. You ask them a series of questions saying, do you recall, Mr. Jones, that you were deposed under oath on July 5th, 2020? Yes. And at that time, were you aware that your testimony could be used later in court? Yes, I was. And did you, take the oath? Then they say yes. Well, can you read lines 52 through 55 on page 95? And then you get them to read what they said aloud. And then you step back and say, now, is that what you just told the court? And then it's clear that they are telling a different story. They might not consider themselves to be lying, but they certainly are not saying the same thing that they said earlier. What does that do? It reduces their credibility with the jury. That is the power of discovery. You discover the facts underlying both sides of the case before you go to trial. Now, what if you discover things and you don't like it? And you realize, wow, we don't have a good case. Gosh, my client really did do what they said. Well, then that gives you the opportunity to decide to enter settlement negotiations. And that's a great thing to do. And most cases do settle at the close of discovery. They do not proceed to trial because, as you are going to see, trial is a very long, involved, and expensive process. So most cases settle, and typically they settle after the discovery phase, because after discovery, each side has the opportunity to see the strengths and weaknesses of all of the sides of the case. And then they realize, this is not the slam dunk I thought it was. I'd like to, cut my losses. I don't want to spend a ton of money going to trial. Let's see if we can't work it out. And that's where, particularly, as I mentioned, I represent defendants. If I have a defendant, even Sometimes if I know the defendant is innocent, and innocent is the wrong word because I do civil cases, you would use that in a criminal case, but they are not liable is how you would put it in a civil case. Even if my defendant I don't think would be found liable, it may be in their best interest from a financial standpoint. Let's just make a settlement offer. Let's offer, $3,000 to end this now, rather than spend, $30,000 going to trial. So what are our steps in the trial? Well, the first step is to select a jury. You've got to select a jury, and typically, hopefully you all know how to become members of the jury panel because you've already taken the steps to become eligible. In North Carolina, in order to serve on the jury, you have to be a registered voter. And you register when you get your driver's license, you can also get on the jury pool at that point as well. So if you're a registered voter, and in some instances, when you register to get your driver's license, this puts your name in the potential jury pool. It doesn't mean that you'll be called necessarily, but at least you are essentially in the bucket of people who are eligible, and you have to be a registered voter. Once you are called for jury service, you will come in, and the attorneys there will conduct a process called voir dire, which is a process of asking potential jurors questions about their background, questions about their knowledge of the case, questions about where they work and how they think about, what their viewpoints are on different situations. Some people might find it a little intrusive. Why do we do this? Because we are trying to use this questioning process to uncover conflict of interest, potential bias, or any other predisposition of a juror to rule in one way or another instead of listening to the facts. We do not want jurors who are going to come in and serve and who've already decided how they plan to vote, or have a tendency to vote based upon preconceived notions and not listen to the facts. We want people to listen to the facts. Each side, the plaintiff and the defendant in a civil case, and the prosecution and defendant in a criminal case, each side has a certain number of jurors that they can remove. They have what are called challenges for cause and peremptory challenges. Challenges for cause are unlimited. That means if you encounter during your questioning a juror that you think is clearly biased, has a conflict of interest, or has some other predisposition that would not favor your client, you may have them removed from the jury pool. That's a challenge for cause, and you have an unlimited number of those. You also have what's called peremptory challenges. They vary by state, but in North Carolina, you have 6 peremptory challenges. Now, peremptory challenges are really interesting. These are provide an opportunity for the lawyer and or their client to remove a potential juror without saying why. You don't have to say why. You don't have to disclose to the judge or to anyone else why you don't want that particular juror to serve during your trial. So, as that sounds, it does create the opportunity for abuse. Peremptory challenges are supposed to be used in the event that, sometimes you can't put your finger on why someone seems like they might not be a good fit. But for instance, maybe because your client is with you while you're going through this process, maybe your client says, well, juror number 4 just kept looking at me funny. And juror number 5, his eyes were shifty and he would never make eye contact with the judge or any of the lawyers. Or juror number 2, sometimes the lawyer have got the feeling that I could tell I could not get any rapport with juror number 2. She was not liking me at all for some reason. I'm not sure I'd want her on the jury panel. Now you might wonder, like, why are those considerations? Well, because when you're in a trial, the jurors have to sit there a long time, and sometimes they get bored. Sometimes it's like when you have a class and your eyes begin to glaze over and you start to notice the hair on your professor's forehead, and you start noticing their funny shoes they have on. Like, your mind wanders and you're not paying attention to the facts, right, of what's going on in the class. That happens to jurors as well. Sometimes you encounter people who just give you a feeling that the two of you aren't going to gel. Potential jurors can do that too. And so the law allows that the parties, the plaintiff and defendant, or the prosecution and defendant, each has the ability to remove, in North Carolina, up to 6 of these potential people. Past 6, you're just going to be stuck with whomever is there unless you have a valid challenge for cause. But then you can use 6 peremptory for the people that you just have a bad feeling about, for lack of a better term. Now, have these peremptory challenges been used in nefarious ways? Yes, they have. There have been many cases, particularly in the criminal context, where the prosecution has been accused of using peremptory challenges to remove all women from a jury panel, or to remove all people of color from the jury panel, or to target people that they think are too much like or too much sympathetic to the defendant. And they can do that until, unless a party is able to prove that the district attorney was using their peremptory challenges in a discriminatory way. That's pretty hard to prove, but there have been many cases that have gone up to actually all the way to the Supreme Court, and it has been held that it is illegal for the prosecution to use their peremptory challenges to remove people from a jury panel on the basis of race or gender. After we get our jury panel selected, you have opening statements. The plaintiff goes first. Each party has the opportunity to essentially tell their story to the jury of what they will hear. It is important that during your opening statement that attorneys only give a forecast of the evidence that they expect to come into the trial. You can't say that someone ran a stoplight during the opening statement, because there hasn't been anyone to come in and testify to that yet. So you might hear attorneys say, the evidence will show, or you will hear. And so they are prompting the jury that this is what you should expect to hear, but I can't tell you that that is what the facts are, because it hasn't come in yet. After each side gives their opening statement, then the plaintiff begins with putting on their evidence. That is, they call their witnesses, they get their documents that they have obtained from you through requested documents in their own. They bring those into trial through witnesses. They put their parties on. When you are examining your own witness, that's called direct examination. Direct examination, you like to use open-ended, nice, easy questions. Ms. Jones, tell us what you did next. And then she tells you what she did. All right, Ms. Jones, then after you crossed the street, what happened after that? And you just let Ms. Jones talk. When the opponent is asking questions of the witness, that's called cross-examination. On cross-examination, lawyers don't want to let a witness just talk. When you're on cross-examination, the attorney wants to control the witness. I'm going to ask direct, close-ended questions. For example, Ms. Jones, you were going 30 miles per hour, weren't you? And she's going to have to say yes or no. Ms. Jones, you were wearing all black, weren't you? Ms. Jones, isn't it true that the brakes on your bicycle were broken? So when I'm asking those type of questions on cross-examination, you could say, I'm doing all the talking as the lawyer. Now, I'm not giving a speech like on television. but I am stating the facts that I want her to agree to. It's very different when it's direct. On direct examination, when it's your witness, you want to let your witness talk. When you're on cross-examination, the other party's witness, you, the attorney, wants to do the talking so that you control the witness. You don't want them getting up there and giving their sob story. You want them to just answer the facts, answer the questions. After the evidence is concluded, so both sides have put on their witnesses, plaintiff and defendant, then you have closing arguments. Plaintiff again gets to go first. Here is where an attorney can, be a little bit more dramatic. In the closing arguments, you're making a persuasive speech, if you will, about the evidence, because now the evidence is already on the record, the jury has heard it, and you're going to essentially tell a story of how the evidence should come together in the juror's mind. After the closing arguments, then the judge takes over. The judge will instruct the jury as to what the law is. This is really important. Remember, judges review questions of law, and the jury is the trier of fact. So when the judge decides what law to instruct the jury on, this is an appealable issue. If the judge gives a jury instruction to the jury that you don't think was accurate, wasn't the right instruction to give, that would provide you a grounds for appeal to go to the appellate court if your client loses. Now, if the judge gives great jury instructions and then the jury just doesn't vote in your favor, you're going to be, probably out of luck. You're not going to have a lot of grounds for appeal unless you had some other procedural issues that you want to debate. In improper jury instructions, I'll add, are one of the areas that in criminal cases, attorneys often look at as a means for appealing a lost trial. All right, so as you can see, there are a lot of elements to the trial. So now you're going to have an opportunity to conduct your own trial.